Good afternoon. Good afternoon. Have you ever thought about something and said, I'll get around to it? Have you ever been staring at a letter that you got in the mail, knowing that you need to respond, knowing that you need to say something, but feeling your heart beating so fast that you just go with your initial kind of emotional reaction and you just put it down and you hope it goes away? Or maybe you've heard or received a letter from the court or maybe another attorney and you had no idea what it was about, no idea where to start, and you just left it alone, only for it to come back again and again and again, and you just ignore it again and again and again. Well, if you have, you're not alone. Okay. We may have all had that feeling at one point or another. But when it comes to our legal affairs, we cannot afford to let that initial emotional reaction of fear or doubt, or maybe our head reaction of ignorance, not knowing what to do, not knowing where to start, we can't let that keep us from acting. All right. And we're going to discuss today three legal matters that you should not ignore. You should not give into the fear. You should not give into the ignorance, the doubt, because if you do, you face actually greater consequences from inaction. All right. Your emotional response just kind of paralyzes you. And that doesn't stop the process from moving on just because you're paralyzed. Okay. It's tough to say sometimes, but these are conversations that I've had to have with clients in the past who were getting these kind of letters in the mail, were facing court action, knowing that they need to take some legal action, but didn't do it. Years go by and the consequence is they have to pay something that's greater than if they would have initially dealt with it in the first place. Okay. So let's talk about three common factors now, and this goes to so many different people. I see this happen with um, accountants. I see this happen with educators. I see this happen with real estate professionals, real estate investors, because the more you ascend to, the more risk they're going to be anyway. All right. So that's why, especially when you're at that level, you cannot afford to let these matters just, hope and pray they go away. You have to take action on it as well. All right. So let's get into the three matters I'm going to talk about today. This is not an exclusive list, not exhaustive at all, but just common that I've seen in practice lately. And I want to discuss with you, explain to you so you don't make these mistakes. All right. So the first one is outstanding legal matters. What do I mean when I say this? Letters that you get from a court documents. Maybe they're bank or financial institution letters. All right, that have some kind of legal implications, something that you may owe, right, a creditor or something like that. But definitely, any letter that you receive from a court, any court documents that you receive, and you know them when you see them. Okay, just like how we all get the jury duty summons and we have to respond to that. You get a court summons if you're being called into court, right? Whether somebody, usually if you get the summons, somebody is calling you into court. That means that they are presenting a case against you. Okay. I see this happen a lot with, I'm here in the city of Detroit, in Michigan. Okay. I see it happen in the city of Detroit a lot, where there are a lot of real estate and investors, professional and kind of amateur or, intermediate, may have a few properties, but still kind of getting the mastery of it all, where they're investing in property and they're getting letters from the city government. Our city government is the largest landlord in the city. Okay. So there are, all kind of bureaucracies and administrative red tape to go through and everything like that. And so uh, investors don't always know this. Okay. Or if they do, they kind of ignore it. And then the red tape just keeps piling up. And, a lot of times, some people, when they get these letters in the mail, a lot of times too, they're just busy professionals. Okay. They just kind of ignore it. Oh, whatever happens, it'll, take care of itself, that kind of attitude. Some people, they might have another professional life over here, but they're kind of dabbling in real estate. So they're not really, excuse me, they're new to the process. So when they get this letter from a court, right, they get this kind of legal action document, they might feel intimidated and unsure. They don't know where to start. Okay. And so because of that, they just, I don't know, I'm going to leave that alone for now. And some people I've heard, come to me for consultation and just think it was outright fraud, right? Because there's a lot of fraud that goes on too. But it ends up being a legitimate case and they think it's fraud, they ignore it. and then they, face consequences later on that the property is being taken from them, or that they're piling up thousands of dollars in fines because they never responded. All right. Delay like that for whatever reason, whether you out of your own ignorance of not knowing what to do. And I say that without judgment, it's just fact, right? Whether it's that, whether it is intimidation, right? Whether it is what's the word I'm looking for? Apathy, like you just kind of don't care one way or another, or do you think it's fraud, right? Or do you think it's some kind of bad intent? You need to be judicious in it and you can't ignore it. Okay. Worst case scenario, take it to a legal professional sooner rather than later, who can tell you, yeah, this is legitimate. You need to answer in this way. Or you say, you know what, this is a scam. And then, help you take appropriate steps to stop that. But more often than not, when I review these kind of cases, they are legitimate. It doesn't always mean that the person is at fault. That's the key. They're just legitimate documents, and you need to be able to answer in your own defense. And when you don't answer, when you delay, when you give into whatever initial feeling that you're having, you run the risk of a default. That means that, okay, you got the appropriate notice, you didn't answer, you didn't respond. Multiple notices have been sent to you, you never answered any of it. Now the other party, and a lot of times in this case, it's the city government, is taking action against you. You never responded. They're going after what's called a default. A default means what it means. By default, they win because you never answered. So let's think about like if it was a sports tournament or a match or something like that. By default, if the other team never shows up, you win, right? That kind of thing. So the person going after you will get a default. It's entered in there. Then after they get that, they can get what's called a default judgment. So that means that, okay, this person defaulted, they never showed up, we win. This is what we're after, whether it's a $10,000 fine, 5,000, 100,000, or we want to take the property from them. That's our judgment. They can enter that, and that's what it is, okay, because you never responded. So that's why it's so important not to delay, because oftentimes you may not even be liable for that stuff. Okay, I've seen it happen in practice where, uh, especially with city government, it can happen a lot. There's some kind of action taken against an investor or a property owner that is not what it appears to be, okay, on the court record. The person has proof of it. Use that proof to overcome these allegations, right? To overcome this case against you. You have to put it on the record, though. That means you have to present it to the courts. You have to present your side of the story, all right? Or else their side is what matters. Their side is what gets the victory. You have to present that. And so don't think that just because you got a letter in the mail, you got a letter from a court, that you're in the wrong right away, okay? Nothing has been decided yet. You have the right to decide or to present evidence in your favor. But if you don't do that, you can't. You can't. Your favor goes away. All right. So don't be afraid. Don't be intimidated. Don't be so apathetic that you just don't do it. And if you obviously, a lot of people are just so beyond intimidated. They're just so over, like, don't even want to deal with the court process. But let me tell you one thing, though. Once you're in it, you have to get out of it. And you don't get out of it any other way by going through it. Okay. So if you don't know how to get through it, if you don't know how to navigate through it, this is where an attorney that knows how to do it can get you through it. And this is where it becomes an investment to you to do it. And I have cases to prove this. Okay. And I'll name a couple. Well, I'll just start with one. This was a little while ago. Someone came to me for a consultation. They were getting all these letters in the mail and not knowing what they were, had never responded to any of them. Okay. Had a property that they owned. It was a 2-family flat. So I think at least one of the spaces was being rented out and the tenant was suing. Okay. Never responded, had multiple notices in mail, never showed up to the hearings, none of that, until they finally contacted me maybe a year and a half or so later and was asking about all this stuff, all these questions that were coming to them. And I said, okay, these are interrogatories, which are questions that people use to collect evidence. This is not the first document that you would have received, though. So I had to kind of go back to the beginning and see that throughout looking at the whole case file, There was already a default entered against this individual, and there was already a default judgment on the individual for $10,000, flat out. Okay. Even though this person was hesitating because they didn't know if they wanted to hire an attorney and do all this other stuff, well, saved on attorney fees, but because they never ever went through the process, they never ever answered anything in response, they never ever put any kind of answer on the court record. The default was entered, the default judgment was entered, and they were like that out of $10,000. Okay. Now, of course, then the next step is collection, right? And that's where things like garnishment can come in, liens on your property, tax liens. I mean, there's all kind of ways to collect that money, to capture that judgment somehow. All right. That's the final step. But did you even have to go through that? If you would have presented some kind of evidence on the record in your favor, right? Or if you would have just showed up and negotiated with the other party, maybe it wouldn't have been all that, but you'll never know now. You just know that you're out of $10,000 right away. And I've seen this happen with $100,000, and I know it'll happen with more. Okay. You got to show up. You can't ignore these things because that's disastrous. If you're out right away out of $100,000 just because you never showed up, just because you never showed up. And it doesn't even mean that you necessarily owed that, right? You just never showed up to even say whether you did or not. And so that's what can happen. And that's just number one. We're only on the first one when it comes to these legal disasters, outstanding legal matters, outstanding court matters. The second one is property protection. All right. So with real property, real estate, it is so critical how you title the property, how you execute the deed, how you protect the property. All right. Because often what will happen, excuse me, is especially when it comes to estate planning, property is always going to be an issue, whether it was grandma's house, mom's house, right? And this kind of generational transfer, it goes wrong so many times because it's not executed in the right way. Okay, so it might be someone's intention to keep the house in the family, but it's never executed properly. There's never a will to say that outright. There's never a retitling of the deed, right, to quit claim it to the next generation or to, do whatever they're going to do with that. It's never put in trust, right? So it just has to go through court every single time. All right. So if grandma died and there's no way to prove what she wanted to do with it other than what she told, a couple of her children, it still has to go to court to find out how we're going to title this property now, how we're going to split it up, if we're going to split it up, if we're going to sell it and just get the shares, or like what's going to happen to it now. So really be mindful of, okay, I have this property. What do I want to do with it next? Is it going to be for that generational transfer? Am I going to want to sell it in the future, right? Is it part of my portfolio? Think about that before you make any action on property. Okay, I saw something recently about just kind of putting a house in a trust because then that way, whoever will inherit it won't get what's called a capital gains tax if it's sold. And a capital gains tax is just a tax on profits. So if you buy something for, let's say, 50,000, and then it sells for 100,000, that difference, that $50,000 difference, gets taxed, right? Where then they were just talking about a way to capture the whole 100,000 so that none of it is taxed. If that's your purpose, okay. But if you are just wanting to make sure that the house goes to the next generation, it's not your intention to sell it, you don't have to do it that way. Okay. So when it comes to real estate and when it comes to trust, when it comes to estate planning, period, what is your purpose in it? What are you wanting to accomplish? Always start with that. Okay. If it's a real estate portfolio, there are ways to protect that. All right. A will, it probably ain't the way to do it because it's just too much, right? Maybe a trust might not be. Maybe you want to do it in a business, right? So just think about it. Think about what your intentions are for those properties. Think about who you're wanting to succeed you with the ownership, the management, the title of those properties. Okay. Because if you do nothing at all, again, delay, you're meaning to get around to creating a will or to creating a trust or maybe getting that deed together, but then you just never get around to it, something's gonna give, right? I mean, you're either gonna sell it, it won't be there. Maybe you pass away and you pass away without taking appropriate action. maybe you even face foreclosure, who knows? Like, the risk of loss is there, but you can control it, you can mitigate it by acting on what your intention is, by acting on what your purpose is for it, by acting on what you wanna do with it. And there are many different ways to do that. Again, um, we talked about just a few. Retitling the deed. Always make sure you always when it comes to real estate, I know you can do a lot of stuff online. Don't do it online without talking to a professional first, okay? If you don't even if you think you got it together, let somebody review your documents because this is serious stuff. We take it for granted because it's so common, people buy houses and we talk about the housing market, interest rates, mortgages, all that stuff. We know it in a broad view, but when it comes to titling the things and transferring, titles and transfers, if you're gonna do that, talk to a professional, okay? Because they can help you avoid taxes. That's a big one, but they can also make sure that the title is clean, if there's no liens on it, that it's transferred in the way you want it to without any unexpected um, burdens. Okay. Always talk to a professional about it. I'm not saying don't follow up on your own with education online. Do that. But when it comes to execution, get some help. Education, educate yourself as much as possible because you never want to go into anything ignorant, not knowing, right? And attorneys will appreciate, anybody will appreciate that you've done some of your homework. Okay, you have this together. It makes their job easier. Okay, it really does. I think about when I go and get my taxes done to my accountant and I have all my paperwork together and I know what this is, I know what that account does, and I just have to give them the things and they do what they do with it, right? But like they're not having to explain to me, okay, well, this account does this for you, that 401k does that. Did you do this? Did you do that? Like it just takes more of their time to try to educate me along the way. S- And also, so they're not doing anything that is over my level of understanding. Okay. Same thing with attorneys. I'm always explaining to my clients, even if they do get it, like, this is what we're doing. This is why we're doing it. This is the advantage. This is the disadvantage. If we're going to take this way, this is why. This is what we're leaving out. Right. Being very full and open and transparent with them, but also them coming to me with questions and I'm answering them. And, clients appreciate that as well. So when it comes to, again, the second factor of property protection, do it. Don't delay. Educate yourself personally. Execute professionally with a professional. All right. Because it can lead to disasters again with losing the property, with going through probate court and having a whole mess and a fight with there. I mean, you can watch any of our past videos, and we have tons of examples about just all the things that come up with property and how you don't want to delay. You always want to make sure that your property is protected. All right. And the final one that we're going to talk about when it comes to this delay, legal disasters that can happen. I say this one a lot too because it happens so often and it's so simple, but it's so common. And that is naming beneficiaries. Name beneficiaries on all your accounts that you can name a beneficiary on. That includes bank accounts, that includes life insurance policies, that includes retirement accounts, any other kind of what we call pay on death or transfer on death accounts where you own something, right? You own the account, there's money in it, it's funded, and you can name someone as a beneficiary to take over when you pass away, if anything happens to you. Um, because if not, what happens, you leave the risk of it going to probate court. And we talked about this a little bit. I believe it was last week's video, kind of probate assets versus non-probate assets. So when it comes to probate court, right, it's a specialized court, part of the court system that deals with particularly distribution of assets after someone dies. Okay, it also deals with guardianship over individuals that no longer have the mental capacity, or if it's children, their guardianship over them. So there's usually some kind of what I call a disability or a death, just to make it simple, right? And there's exclusive jurisdiction there. So when it comes to assets, if it does not have another name on it that can take over after death, it has to go to probate court. That is a probate asset. If it has a name on it that can take over without going to court, it is a non-probate asset. It means it avoids the court system entirely. Okay. Bank accounts are one. Retirement accounts are another. Life insurance policies are another, but they will only avoid probate court if you name a beneficiary on that asset. Okay, so let's say you have $1 million life insurance policy, but you never get around to naming a beneficiary. Guess what? It's going to probate court. And then it'll become the estate of Miss Jones, $1 million. And you know what? Nobody gets the $1 million right away. It has to go through the court process first. If Miss Jones, let's say she had a $100,000 creditor, the creditor can make a claim and get paid out first, and then it's $900,000, right? And it can just keep going down until all of the claims are paid out, all the expenses, court fees, attorney fees are paid out, and then whatever is left goes to whoever her beneficiaries are by law, if they can be found, right? As opposed to, let's say Miss Jones has this life insurance policy, it's $1 million. She names her daughter Mrs. Smith as the beneficiary. Then it avoids probate altogether. Mrs. Smith will be able to collect the life insurance policy, okay? Because that's like a third-party contract between Ms. Jones and the life insurance company. They'll do their investigation. They'll ask for identification, death certificate, etc., and they'll handle it. Has nothing to do with the court, okay? And 9 times out of 10, almost always, the court will not get involved in that if there's a challenge to it, okay? If there's a named beneficiary on there. And then the other kind of downfalls, if you will, of failing to name a beneficiary, you can leave the funds in the wrong hands. So let's say that Ms. Jones had that policy and it was to Mr. Jones, but Mr. Jones is her ex-husband. She never changed it. He's still gonna get the money, okay? And then, you know, it pains me because a lot of times I see this happening where there's bank accounts, there's large sums of money stored away, there's life insurance policies, large sums of money that can be beneficial to that person immediately, to those heirs immediately, but they can't get it immediately because there's no name on it. They have no access to it. You know, $80,000, $25,000, $200,000, doesn't matter the amount. That money is locked away because there's no named beneficiary. That delay leads to a disaster because then the money is not collected and captured immediately for the people that it's intended to protect, especially with life insurance policies. If you pay into it every month, you know, and you're making the payments and all that, but then you have to get stalled because you never put anybody on the policy. I mean, come on, that's a simple fix. That's a simple fix, but it leads to big disasters because then you have livelihood, money, all that stuff just tied up in court that doesn't need to be there. Okay. And so that's our video for today. Legal delays that lead to legal disasters. Ultimately, what I'll say about it is this: you have to be the person that's going to step up and take care of the business. Okay. You know, it seems kind of almost cliche, maybe a little harsh. Okay. But it's going to be on you. It's going to be on you. Nobody else can do it. All right. If that letter is going in the mail to you, you got to be one to take care of it. If you have the property, you got to be the one to say, okay, what am I going to do with it next? If it's your account, you got to name somebody on there, right? But the good thing is you don't need to do this alone. You don't need to do it alone. Again, this is where the education and the execution work hand in hand. So educate yourself on these issues, on these matters. You never want to go into anything completely ignorant, completely in the dark. Okay. But you're not going to be able to solve every problem that you face on your own either. Again, I just mentioned with my taxes, I don't do my own taxes. I'm not a tax professional, right? Even though I know some things about taxes, etc., that's not my area of expertise. So I work with my accountant to do that. All right. People work with me as their lawyer to do it, to do things when it comes to court actions, when it comes to titling assets, when it comes to their real estate, because they have it, right? They went out and got it, but they want to protect it. And they know that there are some things beyond what they already know, beyond their own education, that they need an expert's help for. And so that's where we can come in and help you and partner with you when it comes to the execution of your vision of what you want to see done and who you want to benefit. All right. So with that said, today is December 19th. This will probably be the last live video of the year. We will be back next week for sure. We may do it live, we may not, but we're going to be back with kind of a wind down of what to be doing, what to be looking for, but before 2025 starts and as we begin 2025. Okay. We had our annual review, our Thrive Legal annual reviews. Those are done for the year of 2024. If more spots become available, which they're not open right now, There's a link in the description you can click if you're in the state of Michigan. Click a link to book an appointment and get some help. If not, you can still come back to this channel. We offer pretty general advice, not even legal advice, educational information, put it that way. It's not legal advice, but we offer general legal education for you to consider. All right. And so if you found any value in it, you can definitely like the video, share, subscribe, let us know if it's been helpful, beneficial for you. And we'll look forward to bringing you more into the new year as we come into 2025. And for everybody that celebrates, Merry Christmas. I know I will be enjoying with my family. I hope you do as well. Happy holidays, Happy New Year, all of that good stuff. All right. Take care. We'll see you next week.